I think the question of reparations brings to the fore one of the most pressing debates in international criminal justice, and that really is, what's it for? What is the purpose of this mechanism? And we see this conversation around the purpose of criminal justice in municipal contexts as much as we do in the international context. And generally we look to jurisprudential justifications that oscillate around notions of reparations being, or criminal justice being a theory of deterrence or prevention, criminal justice being about expiation or retribution or retaliation, reformation, and in certain circumstances, social protection. The international context, though, in my view, has three additional components or purposes that are necessary for deliberation and discussion and come up very clearly in the discussion around reparations, and I think they've already come up during the course of the day during the course of the proceedings today. So the first real difference or manifestation of international criminal justice and the purpose of international criminal justice that distinguishes it from national systems, in my view, is who owns it. Right? International criminal justice is very much owned by and serviced for the notion of the global, right? It is driven in response to heinous crimes committed against humanity as a whole and not only against the individual victims. The crime of genocide, for example, is a crime that affects a targeted group, but it's also a crime that affects humanity. It shocks the consciousness of mankind, quote unquote. Women seemingly are also shocked by it. But it does this, there was a joke, thank you. But it shocks the consciousness of humankind in a way that demands an amorphous but deeply moral response that speaks to high-level notions of international justice. And the question of who owns and drives this global project is very relevant to the discussion of reparations. So that's the first purpose that I'd like to discuss. The second purpose of international criminal justice that I think is quite peculiar is the or aspect of it. It's less a purpose. It's really a fundamental characteristic of international criminal justice, is where it happens. For the most part, international criminal justice occurs in transitional states or post-conflict states that are poor. It is very, very unusual that you have, in fact, I can't think of anything since Nazi Germany where there was a post-conflict tribunal or a post-conflict mechanism that was not embedded in a society characterized by economic development. So if you think about currently the International Criminal Court, I think that's a no-brainer, and part of the contention around the work of the ICC at the moment is very much that it's targeting poor and developing countries, particularly in Africa. But the ICTY, the former Yugoslavia at the time, and continues to have an economy that is nowhere near the standard of some of its neighbors, although now with the recent economic decline, I think that's no longer a distinction. But the ICTY was not a flourishing economy. It was not a United States or a United Kingdom. The ICTR is a very obvious example. The Special Court for Sierra Leone, the Cambodia Tribunal, the Peruvian Tribunal. So all of these operate in extremely poor locations, with the result that the individuals in such contexts are not necessarily the beneficiaries of justice. And if you take some of the discussions this morning around the distancing, the alienation, the notion of neutrality, and the imposition of the external into the internal, factors, by the way, which I think are nuanced. They need to be fleshed out, and I don't think it's appropriate to dismiss them out of hand as automatic failures. But those factors, without question, create a barrier between the survivors of the type of violence you encounter or one encounters in these contexts and the people who have survived that violence. So first difference or first issue to consider, that it's globally owned justice. Second issue to consider is that it's a type of justice that occurs often almost exclusively in poor communities. And thirdly, there's another difference. This is another aspect that has to be considered in analyzing the legacy of a tribunal and also the legacy or the issue of reparations. And that is who gets to decide what is criminalized. So for the most part, conduct is criminalized based on the experience of harm by those or the harm of those with the power to drive international criminal justice experience, right? So you have a very homogeneous notion of that which is criminalized. And it's no mistake that the Rome Statute has criminalized behavior that is that fits neatly within the paradigm of that which is right and wrong from a global north and a global south perspective. And it's no surprise, it's no happenstance, at least not in my view, that the crimes of toxic dumping, the dumping of toxic waste, the crimes of trafficking, the crimes of corruption are not international crimes. And that is because the development of international criminal justice, not exclusively, that would be too simplistic, but certainly in large part has been driven by a particular homogenous chauvinist approach to that which is, or to that which ought to be criminalized. And this is no shocking statement, right? We've seen it in terms of sexual violence, as we've all seen and heard today, and we know now. Sexual violence is not new in conflict. It's newly attested in conflict. It's newly dealt with in the law of armed conflict and newly addressed in international criminal law. And these questions, one can call them the triumvirate of W's, the who is owning this process, who is benefiting from this process, and what actually is criminalized. These three questions are at the heart of an equitable reparations program, but they're also at the heart of an assessment of international criminal justice as a whole. And I think we are engaging in a very uncomfortable topic, an uncomfortable topic that necessarily engages the inequity involved in a global economic hegemony. And it's that global economic hegemony that is reflected, in my view, in some of the problems arising in the distribution of reparations, and particularly the distribution of reparations to women. Why to women? Why is this a gendered issue? Well, I think on both my sides, I think there's been a very, very rich articulation of why the mode of reparations for gender-specific crimes is so nuanced. Part of it is about, you're talking about reparations in response to sex, in response to intimacy, in response to violence, power, things that have no commodified quantum, as opposed to the housing restoration scheme, which itself was not terribly successful in the former Yugoslavia, which has a functional response, as opposed to the claims made against the Swiss banks by the Holocaust survivors that has a quantifiable response. This is something that is entirely amorphous and in many ways resists a commodification from the point of view of the survivors as much as it does from the point of view of the international criminal justice model. So we're dealing with a mess when it comes to the crimes and the activity that affected women predominantly in the Rwandan genocide. I won't go through the model of reparations because, again, colleagues have touched on the various models, but I will say that the international right that now firmly exists to reparations, both through the statutes and the rules of procedure of the ad hoc tribunals, but also through the the General Assembly Resolution 6147, all of these provide a recognizable right. But until the Victims Fund of the International Criminal Court, the entity responsible for the provision of reparations is the state, right? So the state must come up with the money for reparations, which is fine on one level, but let me ask you this. Why is it that the international community is deeply invested in the notion of contributing financially to international criminal justice tribunals and mechanisms, but refrains from contributing to the reparation project? And I think it's a question that might have a legitimate answer, but we need to ask the question, why are we comfortable with that tribunal, but we're not comfortable with reparative contribution? So that ultimately, the entire reparations process is either oscillating around symbolic reparations, so that everybody feels better, and by everybody we go back to the original who owns this process, right? The global as opposed to the specific. And we also find that this oscillates around the notion of not actually forking out the amount of money that's necessary here. And again, it may not be there, but there's a huge emphasis on one form of transitional justice intervention and not another, and I think we have to ask why that is. So let me go into a little bit more detail around the problems with the three W's, the problems with the reparation model in Rwanda, and what I think are some of the impediments that will arise in the provision of an equitable reparations process and possibly issues to be avoided. So the first W is the who, right? Who gets reparation? Who gets paid? And there are several methods of identifying, engaging, or identifying individual or categories of beneficiaries of reparations schemes, and again, that's been touched on. There's the approach of all victims, right, the Holocaust approach. Or there's the approach of a category of victims, some of the categorization that we see in the TRC allocation of reparations. But the methodology often, irrespective of whether it's a general or a specific or a category of victims, the methodology almost always asks the victim to be a frontline victim. Almost always, there's this notion of the principal and the secondary, the direct and the indirect victim of a conflict. And historically, that paradigm is very gendered. Right? So the heteronormative manifestation of war historically has had the men on the front line, right? Male soldiers, and in the history of armed conflict, of course, the participation of women as soldiers is very new. And the second, the back row, were the ghosts of the women, children, the elderly who would emerge from the proverbial bushes after the conflict is over to reconstruct that society. And it's the primary frontline victims of war that historically have been identified as those who need to be placed in a position of restoration. But this isn't what war's like today, right? The last 2 decades, war has changed almost entirely. And I take the point that's been made in this audience already, that the genocide was, that Rwanda was not a war, the Rwanda was genocide. But that's precisely a manifestation of conflict today. That's precisely what conflict looks like today. And in 2008, a former UN peacekeeping commander testified that it was probably more dangerous to be a woman than a soldier in armed conflict today. And there's no mystique in this. I mean, by the 1990s, 9 out of 10 people who died in war died as civilians, not as combatants. And this information again arose today. You know, you had no more than 50 armed members of the armed forces on either side actually losing their life. The call it a war, call it the genocide, call it the conflict, whatever it is, the ultimate harm, the ultimate frontline victims, and I use the word victim quite deliberately, are in fact women. This is due to a range of factors. There's a change in war technology. There's also far fewer face-to-face battles. So the result is that conflict is taking place in our villages and cities and homes. But there's another reason why this is happening, because it's very effective warfare. Destroy the group, right? Don't go and just have a fight with the armies on a hill. Don't be ridiculous. Go in, lay it waste, poison the wells, destroy the fields. This is a tactic of war that, in my view, is as deliberate as the tactic of rape. But we have criminalized rape in war as a violation, and that is one of the celebrations that we must not ignore it, that has come out of, in my view, particularly the ICTR. But what we have to look forward to now is what is this other manifestation of deliberate tactic in war that is occurring? And the front line, the direct victims of that are women. So there's a problem with who gets, right? So that's the first W. Then there's the problem with who gives. Who's going to make the decision around reparations? And again here, I think the ICTR is an example of the exception. For the most part, transitional justice entities make decisions around reparations based on what they've heard. And if they haven't heard anything around sexual violence or gender-specific harm experienced during the conflict, they're not going to allocate reparations to that conduct. So why aren't they hearing it? Well, the South African TRC is a perfect example, where the only gendered, or I stand corrected, but the only gendered contribution was around what women's experience were in losing their sons, in losing their husbands, in feeling. There was no personal identification with the entrenchment of black women in South Africa as the maid, right? That violation has never come up in the TRC, but it's a very real violation. So the transitional justice processes, unless they are going to acknowledge and embrace and reduce some of the barriers in accessing such processes, are not going to actually hear about it. And therefore, in allocating reparations, there's always the risk that they'll miss the boat. It happened in Peru, it happened in South Africa, and it certainly stands to happen in other post-conflict situations. How much time have I got? 5 minutes. Okay, brilliant. So the commission or tribunals are going to have a very clear understanding about what gender-specific harm is in order to allocate any type of reparative response to that. So we've had the who gets paid, who pays or who gives the right, and then the final point is the what is it for? What is the definition or the delineation of the criminal conduct that triggers the reparative approach? And this is where we see as I said earlier, quite homogenous approach to harm in the International Criminal Justice Project. And I think it's fueled by two factors. The first is that international criminal justice responds to that which is extraordinary. Right? It's not the ordinary, it's the extraordinary. It's the most extreme violators. I remember anecdotally talking to the former chief prosecutor of the International Criminal Court when he had given a lecture, and afterwards I said to him, do you think there's ever a possibility that a state could be held accountable, state officials could be held accountable for mass forms of domestic violence against women that they allow to occur? And he kind of affectionately, I still can't believe it to this day, he poked me in the tummy in a setting like this and said, oh, that's very sweet. Now, I'm going after, I swear to God, this can't be that surprising to everybody. I'm going after the top 6 criminals in the world, right? It's the extraordinary, it's the extreme. And whether we like it or not, sexual violence is hell of ordinary, right? It's normalized. We may not like it, and we may say that it's a terrible thing, but it's not extraordinary. And the same is true of poverty. These are normalized phenomena, and therefore they do not trigger the type of approbation that a genocide does, that decapitation and disembowelment does, right? We've crossed that river. We've crossed that Rubicon and now accepted that the normalized sexual violence in peace, in fact, in conflict, is an international war crime and a crime against humanity and genocide. But we're yet to cross that line with the full panoply of forms of harm that affect women. The other issue is that reparations are going to respond to, or the criminal justice system is going to respond to those acts which are public, right? And that's why Rwanda could trigger the change. That's why the former Yugoslavia could trigger the change around sexual violence. Former Yugoslavia, you have sex camps. That's what they're there for, right? The Rwanda, it was public. It was incredibly public. This is a new phenomenon in warfare, or at least newly captured, which brings me to the third reason why the definition of that which is harmful is often missed: the media, right? So we are in an era of real-time war, real-time battle and conflict, and you see the hard-hatted, fatigue-wearing journalist out there getting grey hairs in the desert together with the other robust, buff soldiers. And they go into the war zone and they have a tank and they explode and they have all sorts of dramatic conflict, and just like your PlayStation, right? They then move on. But what is left behind is the real conflict. And the media's not grasping that. And the media's not engaging that. And I think asking the media to engage it would require a very nuanced type of media engagement. So I think we've got to be careful of unintended consequences. But we're not capturing it and we're not seeing it. So, sociologists for the longest time have called this the silenced voices. I don't think it's silenced voices. I think it's deaf people who don't listen and hear. But it's real. It's a problem. And it's one that has not yet been overcome, other than in the ICTR and the ICTY in respect of sexual violence. And in concluding, I would want to then comment on how these 3 impediments, the who gets, who gives, and for what, or these 3 issues, also contribute to some of the difficulties and some of the stagnation of the International Criminal Justice Project that we face today. The International Criminal Justice Project is a model that needs to be equally concerned, not exclusively, but equally concerned with punitive justice as it is with restorative justice. Reparations that are restorative and that respond to the voiced needs of individuals. And the truth is that the theorizing and the statement taking and all of the research to determine what the victims and survivors of the Rwandan genocide wanted happened after the ICTR came into being, happened after the terms of reference and the statute. So we're not 100% sure what survivors want. The one of the prosecutors at the ICTR poignantly mentions in one of her experiences that one of the witnesses she went to interview expressed confusion at the international criminal justice response. She said her arm had been cut off during the genocide, and now she could not till her field. She could not understand why the perpetrator of this crime was in a prison in the Netherlands and not back in Rwanda to help her till her land. Stop, thank you. Can I have one more second? Okay. So,
Thank you.
the expensive and robust dedication to international criminal justice at the moment excludes an understanding of economic harm and the beneficiaries of that economic hegemony. I'm arguing very simply for a harm-based approach to international criminal justice that should coexist with a rights-based approach. And I do believe that the ICJ process, the international criminal justice process, must be open to hearing the grief of survivors and not simply superimposing grief of a global understanding of grief onto a situation. And sadly, it is a form of justice that has alienated many, evidenced by the AU's withdrawal. Notwithstanding enormous contributions that international criminal justice has made, and the ICTR specifically has made to this project. But it's been very expensive cost, leaving many wondering why so much has been spent on the trials in court and so little on the trials of survival. That's